Welcome to the ADAI sponsored workshop or webcast dealing with compliance with the new fee statute. This was a result of some suggestions at the last board meeting of ADAI that we put something together and try to give some guidance on compliance. We did do an earlier webcast last spring when the statute was actually enacted, but we're going to go beyond that today and look at some things. All of you should have printed material that was available to you that you could have printed off of the ADAI website or was sent to you by Marty Murphy, and that would include an outline, copies of the statute, and a couple of examples of ads. Now, by way of introduction, we are the four horsemen of the post-apocalypse, and which is the post-class action lawsuit. I'm Ron Smith. To my immediate left, or immediate right in this picture is Mark Mingfield. Immediate left is Don Ray. And Joel Nagel.
Morning, everybody.
This screen will flip to whoever is speaking at any particular given time. So that's the cast of characters. If you have questions or anything that you want to ask or note, you can email one or all of us. Our addresses are there. I think our email addresses are there because we didn't do a phone.
Well, we can have it.
But in any event, so we'll go ahead and get going. We want to talk first a little bit about how we got where we are in this particular process. And as you all know, there was a case, and this is interesting and important, particularly with regard to compliance with the new statute. There was a case that came out of Elkhart, South Bend. Well, no, the actual court was South Bend, St. Joseph County. And it is referred to in point A as GASB. That's short for the ownership of the dealership. But in any event, it dealt with of a failure of the dealer to disclose to the customer the amount of the dock fee, not necessarily anything that's the subject of all these class actions, but it was the actual amount of the dock fee. The allegation was it was never disclosed during the sales process. Now that's particularly important, and hold that thought until we get later on in the program, and Mark's going to discuss that a little bit, and so is Joel. The court in St. Joseph County held that there was a private cause of action on the part of the consumer under the old dock fee statute. The Court of Appeals unfortunately followed suit. And now I'm going to have Don Ray, the association, your association got involved, of course, and filed an amicus brief, which was authored principally in Don's own inimitable style and verbiage. And he can report to you that the decision of the Court of Appeals has been vacated.
Yes, the Court of Appeals decision was vacated because the Supreme Court granted transfer on July 25th. A grant of transfer means that it is willing to hear the case, and it is set for oral argument on September 5. Significantly, the grant of transfer was 5-zip. There were no dissents, there were no recusals. All 5 of them agreed the case should be heard. The grant of transfer had the effect of vacating immediately the Court of Appeals decision, so it is a legal nullity, and nobody can rely upon it as a theory for litigation. All of the class actions, which are approximately 15 in number, the overwhelming majority of which are in the Indiana Commercial Court located in Marion County before Judge Heather Welch. All of those cases are stayed. They will remain stayed until such time as the Supreme Court rules on GASB. Now, It is possible that they could follow the Court of Appeals and reinstate the decision, but given the speed and the unanimity with which they granted transfer, I am very optimistic that we're going to get a limitation on this theory that you can bring a suit under the documentary fee statute, which is found in the Motor Vehicles Act, under color of the Deceptive Trade Practices Act with its treble damage plus attorney fee provision. So Gaspy came down in March. Class actions started being filed by the bucketful in April. The association reacted very quickly because the legislature was still in session and managed to get the new statute passed, retroactive to 2013, the new statute taking effect on May 5. And now we're going to pivot to the main purpose of today's gathering, which is to familiarize you with the new statute and then tell you what you need to do to comply with it, because there are some wrinkles and some differences from what you're used to from before, most of which are advantageous to you.
Well, just again, by way of clarification, the Supreme Court, Indiana Supreme Court, can either reinstate the appellate court decision or modify it or reverse it entirely and set up some other guidelines. And we are optimistic, as Don said, that there will be a reversal. Now, a couple of other housekeeping notes. As we were putting this together, we thought it would be helpful to everyone if we did kind of a pamphlet, a step-by-step pamphlet outlining what's required and how you can comply, and get that out through the association to the dealers, and they can share that with whoever prepares their advertising. So that will be forthcoming in probably about 30 days. Now, in the way of other good news in terms of courts, not only did Don's brief do a wonderful job of helping the acceptance of transfer, but Joel Nagel got a great decision that impacts some of you that are on this webcast and actually would impact all of you if you get into an audit by the Department of Financial Institutions on your convenience fee. So he won a decision the other day at the Court of Appeals, and let him take a couple minutes and tell you about that.
Yeah, real quick on that, since it's not doc fee related, but we won a case in front of the Indiana Court of Appeals that vacated a administrative action by the DFI. It's the first time actually since 1979 a DFI enforcement order has been struck down. So we felt like we had a good case. We were optimistic, but given that history in the past, we weren't quite sure how it was going to turn out, but it turned out very well. So right now they could still appeal to the Supreme Court, but basically the gist of that case is with a convenience fee, the department said that a legal charge, an illegal charge, and that the fee had to be refunded to every customer. The Court of Appeals said, no, not quite so fast. You can't just say it's an illegal charge. You've actually found that in this instance, it constituted what was called a TILA finance charge, and therefore there's a bunch of different ways under TILA that you can look at to determine whether the TILA charge was in fact a charge that's going to be one that is of such that it is going to be given with restitution to customers. So the court is just basically saying you can't just go back 2 years. You can only go back 1 year under TILA, and even under TILA, tolerance amounts and there's some other protections and defenses that you have that you can use. You can't just say it's an illegal charge. So as far as going forward, I think the good news is number one, we do now have the disclosure forms that everybody fills out for the convenience fee charge. So as long as you do that properly and you document it well, there's pretty much no reason why DFI would find that it is a finance charge. But if they do find it's a finance charge, either for the convenience fee or any other charge for that matter, DFI is no longer able to just say that it's a legal charge that needs to be refunded to everyone. They now need to do a calculation and allow you to assert different defenses, and you're much more well equipped as far as your ability to defend yourself on such a enforcement action.
And congratulations on that decision. Okay, into the new statute. The first thing I'd like to do is have you, all of you pull from your 932.2-11.2. It defines document preparation fee, and we're going to show you how that has changed dramatically to your benefit from what the old statute contained. So if you'll pull that, we'll run through it real quick. The term document preparation fee means any fee charged by a dealership concerning the sale of a motor vehicle regardless of designation that includes cost incurred by the dealership for the preparation of documents concerning the sale of the motor vehicle. The term does not include a fee imposed on a financial institution, and that's surplusage. So what I have been telling, or we've been telling people to do, is that in case you get challenged or there is some additional challenge to this, is that this would include every scrap of paper that you got in your possession that deals with the intake of that vehicle, the reconditioning of that vehicle, the pricing of the trade-in, anything having to do with the vehicle into the store, anything having to do with the vehicle while it's in the store, that is any kind of a document that, again, you can point to. And of course, as we did before under the old statute, any particular documents that were prepared solely for the sale to the consumer. So by the time that you get all of those things together, then you've compiled a complete history of the vehicle on the way in the door, in the premises, and on the way out the door. And under this expansive definition, we think that that qualifies as a justifiable fee charge, or an inclusion of cost in the doc fee charge. Don't know if anybody's going to try to challenge that individually. If GASB is reversed, some of the class action people may pick individual suits or something. If GASB is reversed, then that will eliminate 90% of the danger under the class actions and leave people with the plaintiff class action people with crumbs. And I would imagine that's going to alter their greatly alter their how they process these things going forward.
I do want to add something, though. The line in the statute, the term does not include a fee imposed by a financial institution for the purpose of extending credit, is frankly not all that great in terms of draftsmanship. It's narrower than the prior exclusion, which said you can't include documents incidental to the extension of credit. Yet the exclusion is what you must live by, because you cannot try to include, to justify a doc fee, any documentation incidental to the extension of credit, because that then would become an undisclosed cost of credit, which would be a TILA violation. So in that regard, just maintain your normal practice that you've always had, or should have always had, under the old statute, and you'll be fine.
Now, let's define that a little further and give some examples. What about credit reports?
A credit report pull for the purpose of extending credit would be included preparation of the retail installment contract, costs incidental to perfecting the lien, things like that are incidental to the extension of credit and cannot be included. However, efforts that you do to pay off the trade-in are not related to the extension of credit. Those have to do with taking care of an old loan, so those would be okay. But again, just stay away from the extension of credit. And frankly, in the next section, which we're about to get to with the $200 statutory authorization, probably all of these mental push-ups we've had to do over the years to justify the charge being imposed kind of go away. If you stay within the statutory $200 limit, you're going to be fine, because you don't have to justify it. But just bear in mind that you do not want to touch the third rail of extension of credit documents as a cost incurred.
Now, what we also are telling people that we would like to see you label the fee as something more expansive than just dock fee or dealer fee or something that's not specific. I know this is a little wordy, but it does capture the spirit and we believe the letter of the statute, and that is document preparation, comma, compliance, retainage fee. And you could shorten that up a little bit and say doc prep, compliance, and retain, something of that sort. And again, I realize that that's a little wordy, but it certainly encompasses the entire statute. So let's go on to the next section that's in your document package, which is 932.13.7. It basically lays out, the elements are laid out in your outline. Unlawful, in excess of $200, so we've been advising people to stay at $199 if that's where they were before. You can set it anywhere you want. It's interesting under these some of these class action cases, some people were staying with the old $149. And I know that some dealers are staying at $99, and some, of course, are, if there's a factory program for employees, they're limited to perhaps $78 or $98. I think Chrysler maybe has 78, and GM maybe has 98. Not sure what Ford has or some of the others. So, but you've basically got the right to charge under the statute $200. Now, this is separate and distinct from the title processing fee. Joel, do you want to talk about that for a second?
Yes, the dock fee, separate and distinct from the convenience fee charge. Remember, the dock fee is subject to sales tax, and you don't want to embed the convenience fee in there, as I think the department is actually recommending some dealers do in the past. You don't want to embed the convenience fee into the dock fee because the convenience fee is not subject to sales tax. So be sure you separate those two out, not only on the convenience fee disclosure form, but also on the retail installment contract. The Department of Revenue, that position on the sales tax on dock fee was effective April 1st of 2019. So getting back to the statute, subsection A talks about the fee, whatever it is, must be included in the advertised price. And let's talk about that for a second. In terms of how you do advertise, Don?
We had a meeting with the Secretary of State last week that went very well. The statute allows two ways to comply with this. We believe that one is far better than the other and also more transparent. The Secretary of State agrees with us that either is okay. One way to comply is to disclose the amount of the fee in your ad. Prices quoted do not include tax, tag, and documentary compliance fee of $199. That's a perfectly okay disclosure. The other way to do it is to pack the dock fee into the price of the vehicle, but then state under the price includes dock fee of $199. Obviously, the former is much less cumbersome, and it's also more in keeping with what you're used to doing. It's also consistent with the fact that the statute requires that the dock fee be separately itemized on the vehicle order agreement, which is something you've always done and you need to do now even more than ever because of its taxability. So you can go either way, but we strongly recommend calling it out separately.
So now that we've told you there are two ways, forget about the one way. Now the second prong is affirmative disclosure. And this must be not only done in the ads, as we'll see in a minute with some examples, but also in writing during negotiations. Now, it doesn't say at the outset of negotiations, it says during negotiations, but as you'll see in a minute, we're recommending that you do it right up front, right at the outset, and then, in substantial form, so that again, you have complied with the statute at some point, rather than getting buried in the details of the deal and forgetting it to disclose it at the end, or something like that.
And the easy way to do that is to make sure that it's on your final figure sheet or whatever you use as a worksheet in discussing terms with the customer. Make sure that it's always, always on the worksheet.
So let's take a look at the disclosure and some of the advertising rules and suggestions. Again, the key here, if there's one word that applies to all of this stuff, it's disclosure. So if when in doubt, disclose. And that's a good rule of thumb that's served well for 45 years through Magnus and Moss, through a lot of these consumer statutes. Internet advertising, Joel?
Yes, on internet advertising, we've talked about how to disclose it in print, and the same applies to internet advertising. You must disclose it clearly, conspicuously. So if you have the price of the vehicle, the dock fee needs to be in a position that's close to that price, also close as far as in the typeface, how large it is, and also make sure sometimes on different platforms, for instance, a mobile platform could be different than other platforms, that even on a mobile, that the price and the disclosure are very close to one another. If the price is on that platform and on that advertisement, it's important that you keep those two very close to one another. Also on internet, along similar lines, Mark's going to cover something on social media.
Everything that Joel said applies to any media in which you advertise. So one of the potential dangers when you're advertising via social media is you end up with sort of a distilled version of other ads, and sometimes terms or advertising material that's in your print ad only carries over partly in your social media ads. One way to deal with that, and this is something you have to have, I know we're constantly telling you all to make sure you have written policies. At this point, everybody should have a written social media policy, and if you don't, you certainly will need one. And this directs how, among other things, it will direct exactly how you'll put these advertisements on, your Facebook page or whatever social media you're using. Importantly, there should be control over who's responsible for advertising on social media. I think a lot of you now probably have people whose job it is to run social media advertising, in conjunction with people who are handling internet sales. Make sure you adopt, if you don't already have one, an active social media policy. Communicate the policy. Of course, it's not enough just to have the policy. You have to make sure you communicate it and enforce it as well. There are some examples in here, which I believe Joel included. Do you want to talk about those?
Yeah, we have some examples of, actually, maybe they shouldn't be called examples of what not to do instead of just examples. But we've got a couple examples here of print ads, and we wanted to go through those with you to show essentially what they did wrong here. And if you look at the first one, I believe it's the Lexus Golden Opportunity sales event. One of the problems we had with this one really was that it wasn't quite clear on the dock fee disclosure. As you can see, it says total due at signing, $3,999, complimentary first month's lease payment on one, and then another will say same with the total due at signing, but it doesn't really quite explain or give you an idea of if there's going to be a dock fee subject to this particular vehicle. So the dock fee, for the most part, is down at the very, very bottom in the disclosures. And one thing you do want to stay away from, and I know in the past we've been used to making most disclosures down at the bottom like this, but really what we need to do is put it closer up to the actual price of the vehicle itself. So just burying it down there at the bottom is not going to be enough, in our opinion.
Remember what we've told you for years. In the eyes of consumer regulators, a mouse print disclosure that is referenced by an asterisk is the same as no disclosure at all. So we believe that using this ad, that's the one that's kind of golden colored at the top. We think that what should be on this ad is simply a line, not buried in the mouse print at the bottom, in a typeface, at least the size of the lines that say complimentary first month lease payment, that simply says prices quoted do not include tax, tag, and documentary/compliance fee of X. If you put that in the middle of the ad or down at the bottom, but not in the mouse print, you're going to be fine. But we do not think that this ad is formatted complies. And in our upcoming pamphlet that we're going to make available, we're going to try to instruct your ad agencies how to simply use that pamphlet to paint by numbers, hopefully by following simple instructions, get you into compliance.
Now, what we also are going to do is construct a sample social media policy. And this will be discussed at our spring workshops. This is kind of, the social media policy is kind of constantly changing depending upon which administration is in Washington. So we had some examples, and what has happened since the change of administration in 2017 is that a lot of the garbage that was required by the prior administration has been cleansed. So we are going to do an updated social media policy that you can adopt as part of your personnel policies. And that will be included along with that sample in our spring workshops, which this year will be scheduled for March, and there'll be announcements going out on the scheduling sometime in December and the usual locations. So you can stay tuned for
Now, you get coming attractions in these shows too. The other ad we would like to discuss with you briefly is the one that begins "Dear Summer," whatever. As we sat in the office and looked at this, we found it to be a confusing ad, and here's the problem. If you take the first unit, it says save $29.55 or finance for 0.9 for 60 months, or lease for $249. And then under the lease, it says total due at signing, blah, 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 does not include tax, title, license, or $199 dealer fee. Now, here's the critique. We don't like the term dealer fee. You should say something like documentary/compliance fee. But here, the doc fee has only been disclosed in the context of the lease, because it says save $29.55 or 0.9% financing or lease for blah, blah, blah. It is only in the context of the lease that says that. So again, how do you cure the ad? You put a line that says all prices quoted exclusive of or do not include tax, tag, and documentary compliance fee of $199. That way you don't repeat it in these ads, and as in the first example, it's really a screw up because it's only disclosed in the context of the lease.
Now, the good news, of course, is that our guys proofed these ads for the ad agencies and put them in compliance. And we would be happy to do that. There would be a small charge with that. We'd be happy to do that for anybody that wants us to do it. The pamphlet idea we came up with will take care of a lot of these sorts of issues in terms of placement, type size, and those kinds of things. Just be aware that all the advertising rules apply now to social media, including Twitter. So your social media policy should absolutely say that no terms or pricing or terms of sale should be included in any social media ads that your salespeople or the dealership might run. The preferred method is that all social media announcements or of that sort relative to the vehicle should be driven to the dealer's website, where the appropriate disclosures are typically made or will hopefully be typically made. So let's get on to some compliance with the time of sale, Mark.
Okay. Just so you get an insight on what sort of lives we lead, we actually get these advertisements and we sit around over lunch and just talk about them. just building on what Ron said very quickly, try to conceptualize when you're doing, in particular, social media advertising, the idea that you want potential customers to actually go to your website, you want them to travel to you. What you want to try to avoid is take everything from your website and push it out to the entire world. All right, so your social media advertisements should really just be baits to bring people into your websites, where all the disclosures are made. You'll be much better off that way, and you'll be on much safer ground. With respect to compliance, at the time of sale, here's some things to keep in mind. One is, we talked about this a bit yesterday, and Ron had some pretty good ideas, using a separate sticker on the car itself, next to the window sticker, that discloses the dock fee that will be charged as part of that deal. You can provide the customer a worksheet with the amount. Our forms were modified last year, where we actually did the dock fee on the form. So when you're working through the worksheet with the customer, there's a spot on the worksheet where you actually write in the dock fee.
Folks, because not all of them subscribe to the form service. Tell them what the service is.
Okay, so EAI has a forms package that we manage and have been managing for
20 years.
20 years, a very long time. In each year, we modify the forms package and then we offer it through the ADI for sale. And it's just a package of forms that if you have this package, you'll have every document that you can need for.
And we work with DMS providers. They're fillable forms. They're compatible. They can be put into your electronic form systems. The price is a license fee, which gives you a non-exclusive, unlimited license to use them. $500 a year for the first rooftop, $400 for the second, $300 for the third, and so on. We don't want to make money. We just love to sell forms. And so we strongly urge you, if you have not utilized the ADI forms, that you seriously look at them. We're happy to talk to you and look at samples and tire kick them a little bit and see if they are an improvement over what you were using. And I venture to say that they will be, at least in some respects.
For some of you that are older, you may remember Don's comment relative to we don't want to make money, we just love to sell forms, is analogous to the old seat cover Charlie ads. Said he wants to give them away, but his wife won't let him.
I always think of Don's guns when I say that.
Was that his tagline?
Yeah. So just to round this out, so again, use of a separate sticker, you can disclose it there, put it on the worksheet that you put in front of the customer to obviously come up with the price of the car and then the other disclosures. Put it on the menu. This can, I guess, mean a couple different things. One is certainly on the menu of items that you discuss, but also as forms are being created with whatever system that you use, you need to make sure that it's actually on the menu that's used to generate the form as part of the deal.
If you're using DocuPad, you should have it loaded in there.
Yeah.
Or you can. Some people just have a sign sitting on the F&I desk with all that on it.
And that's a good addition to put a sign generally. The issue is if there ever is a legal issue or any sort of dispute, you definitely want backup, something that you can email to us, as part of the deal jacket that we can use as evidence to get rid of any of these potential disputes. Also, disclosure on the retail installment contract. You heard, I believe it was Joel earlier saying, now we know that this is a taxable item. So what we've done as part of our form is we took the dock fee and just moved it up to the top toward the sales price of the car. And then, of course, note that in the deal jacket that the customers received a copy of the retail installment contract, if you don't already have something like that in place.
And of course, again, try to keep all the relevant documents in the deal jacket with the customer's signature, and so that if you have to use it as a defense to any particular claim or administrative or regulatory claim, that you've got that. Now, in terms of the annual adjustment, the statute provides that you can adjust on the consumer price index each year. Now, I've had a couple of enterprising questions come up as can we go back and use the consumer price standard that was in effect in 2013, since the statute it was passed retroactive to 2013.
And this type of thing is why we love you guys.
Yeah, so it provides an annuity for grandchildren and so on, educationally. But we think that that's probably overreaching. We would do it from the effective date of the statute, which is May 5th. Personally, what I would do is let the consumer price index go up for a couple of years, 3 years, whatever, before I bumped it, so that you didn't come up with oddball numbers. But you certainly can do that. Depending on what happens in GASB, we really think if, for example, the appellate court decision stayed, then in effect, then there will be litigation over the constitutionality of this insofar as the retroactivity is concerned. And there is a pending case in the North Dakota, dealing with their farm equipment franchise statutes, which are similar to automotive statutes, where they recodified their statute and sought to apply it retroactively. Farm equipment manufacturers sued, lost in the trial court as to the question of retroactivity, and appealed. Then there was an injunction in place, and the injunction was appealed to the 11th Circuit Court of Appeals, which affirmed the trial court. That's a long way of saying that at this particular point in time, North Dakota statutes, the recodification is stayed pending a final decision on whether or not they are lawful under the Commerce Clause. Now, there's several Supreme Court cases that are a little old that uphold the ability of a state to enact franchise statutes, but we think the retroactivity is a little dangerous. There is
I should also add that we have learned from discussions with opposing counsel in those cases that another tack they may take is to roll with the retroactivity, instead argue that because it's retroactive, the dealers failed to meet the statutory requirement of disclosure at every step of the process through advertising, et cetera. And therefore they violated the statute, but we believe that we can block that with a due process argument. So, you know, the real thing to hope for is that the Supreme Court simply says you can't bring a suit under the Deceptive Trade Practices Act for this particular violation. That wipes out count 1 of all these class actions, and the remaining 2 counts, some of them only have 1 other count, are unjust enrichment. We believe that that should be able to be picked off because in Indiana, you cannot have unjust enrichment if there is a written express contract, and obviously in every one of these cases, there's a written express contract. And the other is fraud, which does not lend itself to a class action treatment because it lacks a common nucleus of operative fact and depends upon individualized misrepresentations. So we really do think that if we can do well with the Supremes on GASB, that those of you who are laboring under the burden of a class action will get that yoke lifted from you.
And of course, again, the use of an arbitration clause in sales contracts is absolutely recommended, because the arbitration provision effectively makes class action lawyers not interested in bringing class actions. They would have to bring separate arbitrations. Several of you have, a few people that are defendants in the class actions do have arbitration clauses. And depending again on what happens with GASB, they're going to be in better shape than the other people that did not have them. Since the class actions have come into being, I know that several of you have purchased the forms package, which does have an arbitration clause in it. Finally, today, we want to tell you that this presentation has been recorded and will be archived for however long we decide to archive it, but theoretically for a few years.
Turner Classics.
So that you can retrieve it on the Automobile Dealer Association of Indiana website and on the Stahl Keenan Ogden website in the automotive page. Use it for training purposes for salespeople, F&I people, whoever you need it for. So hang on to the outlines, and that would be part of your training process. Now, again, we've tried to keep this as short on legal stuff and as good on practical stuff as we can. Sometimes in our business, weeds become prevalent rather than trees or forest, and sometimes, but we try to keep everything in the least common denominator, so hopefully it makes as much sense. Again, if you have any questions, please feel free to email any of the four of us, and we'll try to get back with you either by email or by phone to talk about any specific questions that you would have. So with that, we see we got 120, well, about 130 people, so that's not bad out of the people that signed up. And with that, good luck, go sell them up, and everybody best wishes for making a profit. Thanks.
Thank you.
Thank you.